Hello everybody, welcome. Today's video topic is a juror at trial wants to ask a witness the question in the middle of being questioned. Can he simply raise his hand and says, "Excuse me, judge, I want to ask this witness a question"? Can he do that? You think the judge will allow them to do it, especially here in New York? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is, in New York, no, but maybe. Now, let me tell you what I mean. I'm sitting here. I have my dog sitting literally right in front of me, and I'll show him to you in a little while. And I just want to share this great information with you. So now, let's say this is an accident trial, or a wrongful death trial, or even a medical malpractice trial, right? You now believe that you suffered significant harm and injury at, let's say it's a medical malpractice trial. You sued your doctor, and you claim that your doctor, number one, was careless. You claim that his carelessness was a cause of your injury. And number three, you claim that your injury is significant and permanent. And now you have a medical expert to support all of those claims. So now you've started your lawsuit, right? And now the defense turns around and says, "Hey, don't blame me. I did nothing wrong here. And if I did something wrong," the doctor argues, "hey, so did you, patient." And then he says, "You know what? If I did something wrong, I didn't cause or create or contribute to your injuries." That's another defense that he'll argue. And then he'll say, "Listen, if I did something wrong, and so did you, patient, and maybe whatever I did wrong caused or contributed to your injuries, the injuries that you're claiming, nah, they're really not as bad as you claim them to be." So those are the typical defenses we see in these medical malpractice cases. So now, the defense refuses to acknowledge anything here. They've refused to take responsibility. So what does that mean? It means that the entire discovery process is going to go forward. It means that you're going to be, this case is going to be fought tooth and nail. You're going to say it's blue, they're going to say it's red. You're going to say it's 10 o'clock, they're going to say it's 2 o'clock. Every single thing that you argue in support of your claim, they're going to turn around and say, "No, that's not true." So now, what does that mean for you in reality? It means that your case is likely going to go the distance. The doctor and his insurance companies and his attorney are not going to try and settle this case. They're not going to try and negotiate, which means that you're going to trial. Now, it's going to take 2 to 3 years for the lawsuit process to take, let me try that again. It's going to take 2 to 3 years for your case to get to trial. And now, when you're at trial, here's what's going to happen. We're going to pick 6 members of the community to sit in judgment of your particular matter. We want 6 members of the community who do not know you and do not know the doctor. And now, these people are going to give up their free time. They're going to be compelled to come to court to sit in judgment of your particular matter. They have to decide whether you are more likely right than wrong. They don't have to sit there for days and weeks on end making absolutely certain that what you are claiming is true. Instead, we only have to show that we are slightly more likely right than wrong, that what we are claiming is true. And if we can do that, that means you'll ultimately be entitled to a verdict in your favor. So let's take a look at the title of this video again. The title is, "The Juror Wants to Ask the Witness a Question During Trial," right? So now, during the course of questioning a witness, one of them is confused. One of them doesn't understand either the question being asked or the answer being given. Can he raise his hand and say, "Excuse me, judge, I didn't understand what the witness just said. Could I ask him another question?" Yes or no? What do you think? Is the answer yes or is the answer no? Well, I will tell you, in some courtrooms in New York, there are some judges who are very innovative and very creative. And some judges will actually allow a juror to go ahead and ask questions. However, any of those judges who permit that do not allow do not allow the juror to simply raise their hand in the middle of being questioned by an attorney to say, "Excuse me, judge, excuse me, counselor, I have a question, a follow-up question there." That does not happen. And the reason why it doesn't happen is because the judge wants to maintain order. So let me explain to you the process by which this actually does work. So for those judges, and by the way, there are not that many, for those judges who do allow witnesses to ask questions, here's what likely will happen. The judge is going to tell the jury at the very beginning of the case, listen, if you have questions, here's the process by which we're going to do whatever we need to. Come here, Bentley. Let's say hello to everybody. Okay, everybody, this is Bentley. Can you see him? Let's get him up here. He's a Morkie. He's a mix between a Maltese and a Yorkie. Hi, Bentley. Right now, he loves staring out the window while I'm trying to do work, and he loves to sit in front of the computer. So now he decided to come down off of his perch and hang out with me. Maybe he's going to sit down on my lap while we shoot this video. All right. So here's the process by which the judge tells the jury that this is what will happen if they have questions. The process is, number one, if you have a question, write it down on a notepad that we're going to give you. This way, you're not going to forget it. And now, after the attorney is done questioning the witness, okay, now, if you have a question, simply raise your hand. You will then hand up your question to the court officer, who will then give it to me, the judge. And now, the judge will then review that question. If he feels the question is appropriate, he will then call up the attorneys, sometimes, and make a decision and let them see the question. It will be the judge to ask the witness the question, even though everybody knows it came from this particular witness who had the question. But the key here is that it comes after the attorney has been finished questioning the witness. That might be on direct examination, where his own attorney is questioning him, or it may come during cross-examination after the attorney is done cross-examining the witness. So doing that allows the judge the opportunity to control the flow that goes on during the course of questioning. And now, after the judge asks the question, if he deems it appropriate, now the attorney who was questioning that particular witness will also have an opportunity to ask additional questions to clarify anything that he thinks is necessary. So that's really important to understand. So just because a witness has a question, and just because they've been told they can ask questions, doesn't mean they can interrupt the entire proceedings to go ahead and shout out in the middle, "Judge, excuse me, I want to ask this witness a question. Doctor, can you tell me about X, Y, and Z?" No, that's not how it works. So instead, there's a brief process. And now there are instances where the judge says, "I'm sorry, that question is not appropriate. Let's move on." So why do I share this quick information with you? I share it with you because I really wanted to introduce you to my good buddy Bentley here, who's now out. He's now looking around. He wanted to see what's happening outside. Right, puppy? He's almost 2 years old, and he loves sitting here, sometimes sitting on my lap often, and watching the cars go by. That's really why I wanted to shoot this video. Now, the reality is I wanted to give you an insight into what goes on in these types of civil lawsuits here in New York involving accident cases, medical malpractice cases, and even wrongful death cases. You know, I recognize that you're watching this video because it's coming up in your Facebook feed. And if this interests you and you get sucked in and start watching it, or you truly have questions because you're searching for information on how to solve your particular problem that happened here in New York, what I invite you to do is pick up the phone and call me. And let me put on the screen exactly where you can reach me. You can reach me at 516-487-8207. Let's get that up on here. Okay. Or you can reach me by email at let's try it again, at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day. Bye-bye, everybody.